Hi guys, welcome back to Battle with Ola. This is Mujala Olua and I'm super thrilled to be here once again. Today we want to talk about a very interesting thing that happened in Oyo State about 19 years ago. It's a very interesting drama. It's December and this thing happened in December, started mid-December 2005. Very interesting. It ended up in the Supreme Court and a judicial precedent came out of it. You would often hear people cite Inakoju and Adeleke, Inakoju and Adeleke, in different cases today. What happened in Inakoju and Adeleke? That's what we want to talk about. Don't forget that if you haven't subscribed to the channel, you should do that now. Please like the video, leave me comments in the comment section when you're done watching, or if you have something to say to continue the conversation. And if you need a paid consultation, look in the description box and book a paid slot for tailored legal advice. In Inakoju and Adeleke, which is a political case anyways, the Supreme Court, held or made a decision that is similar to what was held in Garba University of Maiduguri. I'm making the comparison because we talked about Garba University of Maiduguri on this channel. In Garba University of Maiduguri, if you've seen that video, if you haven't, please go see it. We love judicial decisions, judicial precedents on this channel. So we even have a playlist dedicated to judicial precedents. Please go watch that playlist. In Garba University of Maiduguri, one of the most important decisions that came out of that case is that while the university can decide its own affairs and determine discipline and mete out discipline within its own territory and onto its own students, the court will administer the rule of law in all cases. And so in Garba University of Maiduguri, the university was contending that the court cannot decide how they will discipline their students for them. But the court was saying that you can discipline your students however you want, but in disciplining them, you must still abide by the rule of law. So because here you have contravened the principle of fair hearing, that is why the court has, the jurisdiction to talk about fair hearing, to decide whether the affected students were given or accorded fair hearing or not. So the court will always decide on issues of the Constitution, which fair hearing is one of, if you look at chapter 4 of the Nigerian Constitution. Same thing in Muyiwa, Inakoju and Adeleke. In that case, the House of Assembly, the Oyo State House of Assembly, something was going on in the House of Assembly. I'm sure some of or most of the players are still alive and well at the time of making this video. They can speak very much as to what really happened. But this is what came before the court and this is what has been reported. In that case, a section of the House of Assembly, the Oyo State House of Assembly, sat at D. Rovans Hotel in Ring Road, while another set of section or faction sat at the normal House of Assembly, which is in Secretariat, where I used to work. I used to work at the Ministry of Justice in Secretariat, not that I used to work, at the House of Assembly. So, the faction that sat at D. Rovans decided that they wanted to impeach the governor, the then governor Rashid Adewolu Ladoja. So they started the impeachment process, and then, they circulated the allegations. They even published it in the newspaper, Tribune newspaper, to be precise, as reported, in the judgment. And then, they purportedly impeached the governor. And so the faction that was in the House of Assembly, that especially the speaker and some other members and the governor, went to court, the High Court of Ibadan, to ask the court to declare the action of that faction of the House of Assembly as unconstitutional. That is, they can't do that because they suspended the draft rules of the House. The draft rules of the House is what guides how the House of Assembly, runs its affairs, how they sit, what they do, what they're allowed to do. It also states, how they should commence and go about impeaching anyone that they want to impeach. So also the Constitution, if you check section 188, states how a governor or deputy governor can or should be impeached. I'm going to read that section to you. So the speaker, Honorable Adeleke, and some other interested parties and the governor went to court, the High Court, to challenge the constitutionality of the impeachment, saying that they have not complied with section 188. They cannot do what they have done lawfully. And then the appellant, that is Muyiwa Inakoju, who was representing Ibadan Southeast local government, and others, a plethora of other people, an array of other members of the House came by way of a preliminary objection to say that the High Court cannot hear, Honorable Adeleke and the governor and others, that the Constitution, already ousted the jurisdiction of the court to, decide the matter of impeachment of the governor. And if you check the Constitution, if you check section 188, which has about 10 sections, there's an ouster clause there that says that any court cannot decide on this matter. So it's a matter to be commenced in the House of Assembly, and then what they will do. Let me read it out so that we do not mix things up. Section 188. The governor or the deputy governor of a state may be removed from office in accordance with the provisions of this section whenever a notice of any allegation in writing signed by not less than 1/3 of the members of the House of Assembly, stating that the holder of such office is guilty of gross misconduct in the performance of the functions of his office, detailed particulars of which shall be specified, the Speaker of the House of Assembly shall, within 7 days of the receipt of the notice, cause a copy of the notice to be served on the holder of the office and on each member of the House of Assembly, and shall also cause any statement made in reply to the allegation by the holder of the office to be served on each member of the House of Assembly. Within 14 days of the presentation of the notice to the Speaker of the House of Assembly, whether or not any statement was made by the holder of the office in reply to the allegation contained in the notice, the House of Assembly shall resolve by motion, without any debate, whether or not the allegation shall be investigated. Subsection 4. A motion of the House of Assembly that the allegation be investigated shall not be declared as having been passed unless it is supported by the votes of not less than 2/3 majority of all the members of the House of Assembly. Within 7 days of the passing of a motion under the foregoing provisions of this section, the Chief Judge of the state shall, at the request of the Speaker of the House of Assembly, appoint a panel of 7 persons who, in his opinion, are of unquestionable integrity, not being members of any public service, legislative house, or political party, to investigate the allegation as provided in this section. The holder of an office whose conduct is being investigated under this section shall have the right to defend himself in person or be represented before the panel by a legal practitioner of his own choice. A panel appointed under this section shall have such powers and exercise its functions in accordance with such procedure as may be prescribed by the House of Assembly, and within 3 months of its appointment report its findings to the House of Assembly. Where the panel reports to the House of Assembly that the allegation has not been proved, no further proceedings shall be taken in respect of the matter. Where the report of the panel is that the allegation against the holder of the office has been proved, then within 14 days of the receipt of the report, the House of Assembly shall consider the report, and if by a resolution of the House of Assembly, supported by not less than 2/3 majority of all its members, the report of the panel is adopted, then the holder of the office shall stand removed from office as from the date of the adoption of the report. No proceedings or determination of the panel of the House of Assembly or any matter relating to such proceedings or determination shall be entertained or questioned in any court. In this section, gross misconduct means a grave violation or breach of the provisions of this Constitution, or a misconduct of such nature as amounts, in the opinion of the House of Assembly, to gross misconduct. So that's the content of Section 188 of the Constitution. Now, don't forget that a faction sat at a hotel and purportedly impeached the state governor. Now, another faction alongside the state governor, including the Speaker of the House of Assembly, has gone to court to say, declare their action null and void. and unconstitutional as having not followed Section 188 of the Constitution. Now, that faction that sat at the hotel has come with a preliminary objection saying that, High Court, you cannot hear this matter because subsection 10 of Section 188 of the Constitution precludes the court from entertaining any matters regarding this kind of proceedings or the report or the outcome of a panel that was constituted to impeach the governor. Now, the High Court Justice Ige decided that he had no jurisdiction indeed. So he held in favor of the defendants, those who had brought a preliminary objection. So the case went to the Court of Appeal, not on the substantive matter now, but on the preliminary objection. When a preliminary objection is made, the court will rule on it. So there was a ruling, that's a preliminary objection. And that was in 2005. That was before the courts, adopted this new trend or fashion of taking everything together. So these days, if you give a preliminary objection, most times the court will continue the matter and take everything together at judgment. So some courts do this, to my knowledge and my experience. But in this case, the court decided that he had no jurisdiction to hear the matter. So the case went to the Court of Appeal, where the Court of Appeal then disagreed with the High Court and said that the High Court indeed had jurisdiction to hear this matter. If Section 10 has said that the court cannot hear matters relating to impeachment proceedings or the outcome of a panel constituted, look at the other subsections of Section 188 from 1 to 9 before 10, which is the ouster clause. Have they been complied with? Was the proceedings done as should be done? This thing was done outside the premises of the House of Assembly's complex, which is an anomaly. And then all the members were not served with the allegations of misconduct against the governor. And what they say the governor has done, is it even gross misconduct to start with? The governor himself, was he served? It was published in a newspaper. He wasn't served on him personally. Did they observe the 7 days notice? And after 7, did they decide by 2/3 majority of the House that the allegations are worth investigating? Was a panel constituted, including those members of the society who are not publics, who are not holding public offices, who are not members of the legislature, who are not belonging to any political parties, who are above board like Caesar's wife? Was the panel constituted, and was there an outcome of the panel? Is that what resulted in the impeachment? No, all these things were not done. So you cannot invoke the ouster clause to defend an illegality. The court held that the High Court could actually hear the matter, because it was a matter of deciding if the Constitution had been complied with. The court is clothed with jurisdiction to administer the Constitution. Also, this case also established the fact that where anything has been done that is inconsistent with the provisions of the Constitution, to the extent of its inconsistency with the provisions of the Constitution, such actions are null and void and of no effect. That is what Section 1, subsection 3 of the Nigerian Constitution says. So, the case then went to the Supreme Court, because those who had filed a PO disagreed with the judgment of the Court of Appeal. Then they went to the Supreme Court, and that is where we had Muyiwa Inakoju as the appellant, and others against Adeleke and others, including Senator Adewale Ladoja, who was the governor of Oyo State at the time, who had been purportedly impeached. So the Supreme Court agreed with the Court of Appeal by saying that the court is clothed with jurisdiction to administer the Constitution. The court is not meddling in the affairs of the House of Assembly. If the House of Assembly had not suspended its draft rules and they had complied with the provisions of the Constitution, followed due process in the impeachment process, the court will have no jurisdiction whatsoever to meddle in their affairs or to tamper with whatever they have done. But he who comes to equity must come with clear hands. They have not even complied with the provisions of the Constitution. You cannot then invoke one part of the Constitution to defend an illegality. If you are saying that by subsection 10 of section 188 we cannot hear this matter, have you complied with section 1 to 9 of that same Constitution? No, things have not been done properly. So on that, on the provision of the Constitution, the court can administer. Even the Supreme Court went ahead to say that apart from administering the provisions of the Constitution, the Court of Appeal should have just, by the powers conferred on it, could have gone ahead to even decide the substantive matter after deciding that it had the trial court, had had jurisdiction to hear the appeal. The Supreme Court held that instead of sending the matter back to the trial court, you could have just moved. Now that you've decided that the trial court could have heard the matter, you could have just moved on to the substance of the case and just decided upon it. So what is the most important thing that we're learning from Muyiwa Inakoju and Adeleke? The most important thing that we can learn from Inakoju and Adeleke, or that was espoused by the Supreme Court, is that you cannot profit from an illegality. You cannot ignore subsections 1 to 9 and then claim that 10 is for you. You have to comply with the law. Also, another important and perhaps even more important is that matters of the Constitution must be strictly complied with. You cannot, go against the Constitution and then claim that you are acting in a legislative capacity. The judiciary is there to interpret the law, and the Constitution is the ground norm. So if your actions are inconsistent with the Constitution, they will be null and void to the extent of their inconsistency. Also, the court also held in Inakoju and Adeleke, because one of the contentions of the party that purportedly impeached the governor was that Honorable Adeleke was a busybody. He had no local standing to even institute the case at the High Court, and the Supreme Court held that how can you say that the speaker is a busybody when, if you paid attention to section 188 that I had read from the Constitution, clothes the speaker with an actual responsibility alongside other people, the speaker, the judge, those 7 persons in the society who must be above board, persons of integrity, not belonging to a political party, all of that. It clothes them with specific duties in the impeachment process. So if the speaker has come to court to say that you have usurped his duties and you have not followed the Constitution, he is right and he has right of standing to be heard by the court. He is not acting for the governor, because they were contending that he was acting for the governor. He was the governor's puppet, so to speak, that, the governor, they were trying to contend that the legislative arm and the executive arm should be separate. But the court held that he was in line because he had a constitutional duty in the impeachment process, which he had not been allowed to fulfill. So he had local standing to institute the proceedings. Essentially, what we learn from this is that, if you listen to this, and if you're a Nigerian, or if you know about Nigerian politics generally, you will know that there's more than meets the eye. But what we can learn from this is that emotions must not prevail. Where there are laid down principles, and procedures for doing certain things, especially if it's laid down by the Constitution, those things must be complied with. Else, those actions done against the laid down procedure will be null, void, and of no effect. Also, there's a sanctity that must be preserved of all arms of government, and this is what the Constitution seeks to do. You cannot sit in a hotel, convene, a meeting of the House of Assembly in a hotel when there's a secretariat, there's a House of Assembly complex for that. You cannot suspend the draft rules of the House of Assembly when those rules are supposed to regulate the conduct of proceedings of the House of Assembly. Essentially, the law will not back an illegality. So the court was right in administering the Constitution. It was not usurping the duty or the powers of the legislature. It was only implementing and setting things right. So this is what happened in Inakoju and Adeleke. And today it's a judicial precedence. When I hear Inakoju, I heard someone called Inakoju a few weeks ago. That's why I remember that, I wanted to do this video. So I just remember Inakoju and Adeleke straight away. Sometimes even when they call someone Adeleke, I remember Inakoju and Adeleke. This is a judicial precedence that talks about the sanctity and the supremacy of the Constitution, and the fact that you cannot profit from an illegality, and laid down procedures must be strictly followed, especially when they are laid down by the Constitution. I will see you in my very next video. Don't forget to subscribe. Toodles!